Rights Act. Because in 2013, the Supreme Court issued its 5-4 decision, Shelby County versus Holder. It essentially nullified a key provision of the Voting Rights Act of '65, Section 5. That Section 5 required localities with records of discrimination against voters of color through racist policies like poll taxes and literary tests to ensure any changes to their voting rules were vetted by the Justice Department before they could be enforced. This requirement is known simply as pre-clearance, and it applied to redistricting. But that pre-clearance requirement, the guarantee of accountability to the voters and adherence to the law, was eliminated by the Supreme Court in Shelby. As today's witness, Assistant Attorney General Kristen Clarke, has explained, in the absence of a pre-clearance requirement, jurisdictions have less incentive to involve community contacts in the elections process and the process of considering and adopting voting changes. Losing this avenue of participation is particularly harmful for minority voters. Americans have every reason to be concerned about the lack of transparency in this year's redistricting. Without full protections of the Voting Rights Act, state legislators could redraw districts in ways that unlawfully diminish the power of voters of colors. And the truth is, state lawmakers have already taken unprecedented steps to silence the voices of American voters. This year alone, legislators throughout the country have introduced more than 425 bills with provisions to make it harder for people, particularly people of color, to vote. 19 states have gone on to enact 33 of these laws. Some of them set new limits on voting by mail. Others cut hours on polling locations. All of them are designed to achieve the same outcome: new barriers to the ballot box. The proponents of these laws claim they are designed to help prevent so-called voter fraud. But facts show that claims of voter fraud are nothing more than grist for the mill of the big lie. Remember when the former president insisted that he actually won the election last year? He's still at it. That election was branded by his Department of Homeland Security as the most secure in American history. Earlier this month, a team of Republican-backed, quote, cyber ninjas, that's what they call themselves, completed a months-long audit. They collected millions of dollars from right-wing organizations to fund this undertaking. This was going to be a months-long audit of the 2020 election results in Arizona to prove once and for all that Donald Trump finally won. What did they find? More votes for Joe Biden and fewer votes for Donald Trump. Despite this overwhelming evidence, the myth of voter fraud persists. Sadly, it's being weaponized by those who hope to advance their own political ambitions by discrediting our electoral process. So if state legislators and others are going to defame and diminish our democracy, we in the Congress have a duty to defend it. With the John Lewis Voting Rights Advancement Act, the Senate has an opportunity to reinvigorate one of the most important pieces of legislation in American history. I've been here a few years. I can actually remember, and I'll bet Senator Leahy could too. This was a big bipartisan issue. Over the years, Democrats and Republicans voted the same way on the Voting Rights Act. In the words of Senator Mitch McConnell, quote, when he voted for it once, this is a piece of legislation which has worked. I think he's right. Let's keep it working. In our nation, there is no freedom more fundamental than the right to vote. And as our old friend John Lewis said before his passing, it's the most powerful nonviolent tool we have. Our democracy is strongest when every eligible voter votes. I'll now turn to Senator Leahy, the lead sponsor of the John Lewis. Oh, I'm sorry. First, it looks like I'm going to turn to my friend, Senator Chuck Grassley, and then Patrick Leahy. Senator Grassley, I'm sorry.
H.R. 4 was crafted in the memory of the late Congressman John Lewis, and it's about voting rights that he fought for and appropriately honored for. The unfortunate reality is that this hearing is another attack on the Supreme Court, and this bill is yet another attempt at federal takeover of state and local elections. It wrestles control of elections away from the state and into the hands of the Biden-Harris Department of Justice and partisan lawyers backed by dark money groups. Before discussing the matter at hand, I want to say that we're grateful to have a number of extraordinary busy state officials and former state and federal officials we heard from who were eager to testify against this bill. This was even more impressive for this hearing, given that the second panel was unsettled until just last Friday. We truly appreciate all their efforts and their outreach. Revising and reviewing this bill, I can see why so many experts were willing to rearrange their schedules. This bill is a disaster. It penalizes states for voter ID laws, which an overwhelming majority of Americans support. Even Democrats claimed to support ID laws earlier this year. It fundamentally changes who is responsible for elections in America, replacing states with the federal government. Why change what has worked for 240 years, in which the Constitution is very clear that the manner of holding elections is up to state legislatures? This is the fourth hearing regarding voting rights in the United States Senate this Congress. We had a subcommittee hearing 2 weeks ago on the same topic, but this did not seem like a process designed to learn more from the experts and state officials responsible for running elections. It seemed rushed so that we could say that we had another hearing. Look at this bill's history. This bill has been proposed in various names and with slightly different provisions all the way back to 2015. It was proposed in direct response to the Supreme Court's 2013 decision, Shelby County. That case recognized that the landscape in America looked very different in 2013 than in 1965, when the Voting Rights Act was passed. And the Supreme Court concluded that Congress couldn't keep requiring states to pre-clear with the federal government election law changes based on data going back to 1965. Fast forward then 8 years, and the Supreme Court again issued a decision, this time the Brnovich versus Democratic National Committee. This case, the Supreme Court set forth a list of substantive guideposts to determine whether, considering the totality of the circumstances, changes to voting rules are lawful under Section 2 of the Voting Rights Act. Unsurprisingly, Democrats immediately set about revising this bill to overrule the Supreme Court's common sense decision. The latest version doesn't just revive the pre-clearance procedures in place before Shelby County, it massively expands pre-clearance. Democrats also want to erase the very reasonable factors that the court outlined in Brnovich to guide lower courts as they look at the totality of circumstances for changes to voting laws. H.R. 4 replaces those Supreme Court guideposts with a list of undefined and far more vague factors, such as difficulty complying with voting requirements. These factors don't provide any legal clarity. What they do provide is enormous opportunity for mischief by Democrat lawyers. If the activist lawyers, backed by an unending flow of dark money, can find a few violations under this amorphous standard, then a state is subject to preclearance. That gives DOJ control over jurisdiction for a period of 10 years. As written, H.R. 4 would also give the Department of Justice the power to retroactively look back at a jurisdiction to determine whether, in the past 25 years, the jurisdiction had sufficient number of violations to warrant imposing preclearance right now. Preclearance worked wonders in 1965. It was needed to ensure the vote for minority communities that were denied the right to vote by poll taxes and literacy tests. Those laws have thankfully been erased from the books. We have recently had record turnout for minority voters. So why are we expanding pre-clearance in 2021? Do we really want the Department of Justice exerting this level of control over our states? This is the same DOJ that only yesterday distributed a memorandum vaguely threatening to use the FBI to investigate parents protesting school teaching critical race theory in the classroom if those protests, quote unquote, intimidate school board members. Do we really want to give partisan activists who claim that paying for postage stamps to mail in a ballot is a poll tax the ability to subject a state to burdensome federal regulations and oversight? Do we really want to give Democratic operatives unfettered power to bring states under preclearance with lawsuits resting on vague notions of quote-unquote violations? To that end, I hope to hear from Attorney General Rokita, who was previously Indiana's Secretary of State, why it's so important for states to manage their own elections, and while federalized election laws are bad for election integrity and, most importantly, voter participation. I hope to hear from the Honorable Ken Cuccicelli, who was the Attorney General of the Commonwealth of Virginia when preclearance was outlawed, the impact of imposing preclearance procedures would have moving forward. Now, before I wrap up, I'd like to take a moment to introduce, for the record, two written statements that I believe warrant recognition. Lieutenant Governor Mark Robinson's described the flaws in H.R. 4 and noted that, quote, this legislation is nothing more than an attempt to ensure that one party control the machinery of our government in perpetuity by mandating an unconstitutional federal takeover elections in our country, end of quote. I also appreciate that a legal advisor to the bipartisan Carter-Baker Commission, Thorne Hearn, noted that H.R. 4 is the, quote, the antithesis of the Carter-Baker Commission's bipartisan recommendations for election reform, end of quote. We would be wise to heed their concerns with regard to H.R. 4s. So sadly, my Democrat friends seem to disagree. They're pushing H.R. 4 to take away the ability of states to establish their own voting rules. We should all agree that participating in American democracy at the ballot box is a fundamental right. It's a right that we should want to protect and not outsource to political operatives in DOJ and activists outside groups. Thank you.
Thanks, Senator Grassley. Senator Leahy.
Well, thank you, Mr. Chairman. I know that my friend Kansas, Senator Grassley, was talking about H.R. 4, but I would note to him we're here to discuss my bill, S4, which has dramatic changes from the bill he was talking about. It's the John Lewis Voting Rights Advancement Act. I've championed this for years. The Voting Rights Advancement Act, as you've noted, Mr. Chairman, has been bipartisan for many years, just like all the efforts to restore the Voting Rights Act before it. And I hope it continues to get bipartisan support as it has always had. Like the evolving decisions from the court that impact the Voting Rights Act, well, then this legislation also must evolve to address emerging concerns. It may be surprising to some when they hear the rhetoric to learn that the Voting Rights Act improving and strengthening and reauthorizing it has been an overwhelming bipartisan effort for decades. We seem to be in an era of toxic partisanship, and I hope that will not obscure what has for decades united us across party lines. Republican and Democratic members of this committee voted in support of reauthorizing the Voting Rights Act in 2006. In fact, it wasn't long ago. We stood side by side to unanimously approve the 2006 reauthorization of the Voting Rights Act. We even stood together with the House and Senate members, Republicans and Democrats alike, on the steps of the Capitol. And you have about as broad a spectrum of ideologies among the Republicans and Democrats in that picture as you can imagine. So I wonder what's changed in such a short time. The belief that protecting our right to vote is bigger than party or politics, that's not novel or new. I know in my state of Vermont, we fight to make sure everybody has a chance to vote. It's a belief that a system of self-government, a government of, by, and for the people, is one that is worth preserving for generations to come. And that's why the John Lewis Voting Rights Act is here. It seeks to ensure that Americans of all parties, all races, all backgrounds, they have the right to vote protected. It's not, nor has it ever been, an effort to empower one party over the other. You know, we insist on all people being able to vote in Vermont. It's not for one party or the other. In the last election, we elected a Republican governor, elected a Democrat lieutenant governor. It's not about a federal takeover of elections. It's not about empowering fraudulent voting. It's about empowering citizens to fulfill their constitutional duty and exercise their legal right to vote. And we as elected representatives of the people, I'd be able to agree that that's a right worth protecting. So the legislation I introduced yesterday is the culmination of many months of negotiation, both here in the Senate and the House, and consultation with the Department of Justice. And I couldn't help but think that's the sort of process Congressman Lewis would have embraced. The Supreme Court's Shelby County decision decreed that Congress has to build a fulsome record of current voting conditions and then premise any legislation restoring the Voting Rights Act on that record. Well, we've methodically, for years, done just that. So what does that record show? It demonstrates action from Congress is needed and demanded to defend against efforts to restrict the right to vote in states across the country. The House answered that call. They passed a bold version of the John Lewis VRA this summer. We did our part by introducing a Senate version that stayed true to the goals of the House-passed legislation and incorporated input we've received through ongoing bipartisan conversation. So this shouldn't be a partisan issue. It never has been, not in all my years here in the Senate. And I'll continue working in good faith with senators of both parties to find common ground. Remember, we have one thing that goes beyond Democrats or Republicans, and that's protecting our precious right to vote. That's what gives democracy its name. That's more important than any party. Every one of us should recognize the sacrifices of people like our friend and hero, John Lewis. The question is, are we willing to live up to his example, put aside our differences, and do what's right for democracy? I know we can. The question is, do we have the will to try? I hope we do. Thank you, Mr. Chairman.
Thanks, Senator Leahy. Senator Cruz?
Thank you, Mr. Chairman. The hearings that Democrats decide to hold demonstrate their priorities, what they care about. We have a crisis raging on our southern border right now because of Joe Biden's lawless and open border policies. The head of the Biden Department of Homeland Security is informing its staff to prepare for up to 400,000 illegal immigrants crossing this month. And yet the Senate Judiciary Committee has not had a single hearing on the crisis on our southern border. Over 2 million illegal immigrants streaming into America, Democrats don't care. Hundreds of thousands of kids in cages, Democrats don't care. Every Democrat on this committee went on TV on and on about kids in cages, kids in cages. You now know what they were saying they didn't believe, because if they believed it, there are more kids in more cages that are more full now than there ever were, and not a Democrat on this committee cares. Hundreds of thousands of illegal immigrants with COVID. Democrats don't care. Children by the thousands being physically and sexually abused by human traffickers, Democrats don't care. Drugs streaming across our border, Democrats don't care. Young women being trapped in sexual slavery by human traffickers, Democrats don't care. Well, what do they care about? Well, this illustrates what they care about. Democrats have one priority, and that is power, staying in power. That's why Democrats have had 4 hearings on amnesty. They look at 2 million illegal immigrants and they think, ooh, future Democratic voters, let's give them all amnesty. Never mind the abuses that happen. This is about power for our Democratic friends. But you know what? There's something they've had more hearings on than amnesty, and that is the federal takeover of election law and the Democratic power grab. There is nothing that is a higher priority for Democrats than staying in power. The Corrupt Politicians Act was so brazenly political, it was such a naked power grab, that Democrats have abandoned it where they realized they couldn't defend it with a straight face. So this is their fallback provision. Senator Leahy mentioned his version of the bill in the Senate. That was filed at 12:45 last night, is when committee members were notified of it. And there are a lot of terrible provisions in the bill, but let me just cover 2 briefly. Department of Justice preclearance for everyone Democrats don't like, and Department of Justice preclearance for everything Democrats don't like. Here's how it would work. Every state and local government across the country would have to submit certain voting changes. What voting changes? Well, anything like imposing voter ID on elections or preventing ballot harvesting, to Kristen Clarke and Vanita Gupta, 2 partisan activists who haven't been shy about their hatred of voter integrity laws before those changes can go into effect. All right, spoiler alert, if it is a law protecting the integrity of the election, if it's a voter ID law, if it's prohibiting ballot harvesting, the partisan activists at the Department of Justice are going to object because they've been explicit they oppose all those laws. Similarly, any state and local government that the Democrats don't like, they have to submit every voting change to the same partisan activists. Let me give you an example of how crazy this is just by analogy. Can you imagine if Republicans proposed a law that said that states like California and New York and Illinois have to submit every law or policy affecting religious liberty or affecting firearms to a brand new division of the Department of Justice staffed almost entirely by activists who've been fighting in favor of religious liberty and in favor of the Second Amendment their entire time? And if these activists objected to the California or New York law, then the states couldn't implement them. That would be absurd. That's what the Democrats have done. And ironically, the Democrats claim they're protecting the right to vote. This bill is an assault on the right to vote. Why? Number one, ballot integrity acts like voter ID acts prevent voter fraud. Sadly, Democrats have looked at the bipartisan Carter-Baker provision, chaired by former Democratic President Jimmy Carter, and just about every recommendation on how to prevent voter fraud, they've turned on its head and said, we want more fraud because fraud benefits Democrats. But secondly, the laws that they want unelected bureaucrats to strike down are laws adopted by democratically elected legislatures in the states. You don't get to claim, as Senate Democrats do, that you favor democracy when you propose measures to stop democracy. Democracy means the voters decide. This bill is an assault on democracy because it says we don't care that 29 million people in the state of Texas decide we want voter ID in accordance with the views of 80% of Americans. We don't care. One unelected bureaucrat at the Department of Justice who happens to be a radical left-wing Democratic activist has the power to say to hell with democracy, we're striking down laws passed by democratically elected legislatures. This is a power grab, it's cynical, and it's wrong.
We will now turn to the first panel. On our first panel, we welcome the Assistant Attorney General for Civil Rights, Kristen Clarke, back to the committee. Assistant Attorney General Clarke is a lifelong civil rights lawyer, spent her entire career in public service. At the Justice Department, she oversees federal civil rights enforcement efforts and works to uphold civil and constitutional rights. She first began a career as a trial lawyer in the Civil Rights Division. Before her confirmation to her current role, she served as president and executive director of the Lawyers Committee for Civil Rights Under the Law. Let me lay out the mechanics for the rest of the hearing. After we swear in the Assistant Attorney General, she'll have 5 minutes for an opening statement, then rounds of questions, and I hope each senator will abide by our standard to try to keep their questions to 5 minutes or less, as we have some roll call votes, which will call some senators out of the committee from time to time. Following that, we will switch to our second panel, and Senator Ossoff will take over presiding. We will once again have 5-minute opening statements from each witness and 5 minutes of questions per senator. Assistant Attorney General Clarke, could you please stand to be sworn in? If you'd raise your right hand, do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that she answered in the affirmative. Please proceed with your opening statement.
Chairman Durbin, Ranking Member Grassley, and members of the Senate Judiciary Committee. My name is Kristen Clarke, and I serve as the Assistant Attorney General for the Civil Rights Division of the U.S. Department of Justice. Thank you for the opportunity to testify on the department's work to implement and enforce the Voting Rights Act and the need to revitalize and restore the Act. The Voting Rights Act is, as President Johnson said, one of the most monumental laws in the entire history of American freedom. It is a law that has helped to truly transform American democracy. However, the progress we have made is fragile. Recently, there's been a resurgence in attacks on voting rights, including cuts to early voting periods, burdensome restrictions to register or vote, racially gerrymandered redistricting plans, polling sites eliminated or consolidated in communities of color, eligible voters purged from the rolls, and more. I am here today to sound an alarm. For the Justice Department, restoring and strengthening the Voting Rights Act is a matter of great urgency. The Supreme Court's 2013 Shelby County v. Holder ruling suspended the preclearance process, eliminating the Justice Department's single most powerful and effective tool for protecting the right to vote. Before Shelby, the preclearance process enabled the department to swiftly block the implementation of many discriminatory and unconstitutional voting practices. Through Section 5, the department blocked over 3,000 voting changes, helping protect the rights of millions of citizens. In over 60% of blocked voting changes, there was evidence of intentional discrimination. We also know that the preclearance requirement deterred many jurisdictions from adopting discriminatory changes in the first place. Too many jurisdictions have viewed the Shelby ruling as an invitation to adopt rules that disadvantage minority voters. Today, jurisdictions that want to restrict voting rights have what the Supreme Court memorably described the advantage of time and inertia. These new laws can be challenged only through long, protracted, resource-intensive, case-by-case litigation, which we have pursued in states like Texas and North Carolina. We are on the cusp of another potentially transformational moment. A new redistricting cycle has commenced. 2020 census numbers show the U.S. has become an increasingly diverse nation, with population growth attributable to increases in the number of people of color. Absent congressional action, this redistricting cycle would be the first in half a century without the full protections of the Voting Rights Act, and jurisdictions may be poised to dilute the increased minority voting strength that has resulted from these natural demographic changes. Without preclearance, the Justice Department will have limited tools to obtain documents and to assess where voting rights are being restricted, thereby hampering enforcement efforts. The John Lewis Voting Rights Advancement Act addresses several of the barriers I've referenced which are impeding the department's efforts to protect American citizens' right to vote. First, the Act responds to the elimination of the preclearance coverage formula by updating the relevant criteria so that Section 5 coverage is tied to current conduct by jurisdictions. Second, the bill provides greater clarity regarding the appropriate legal standard in Section 2 vote denial cases. Third, the legislation gives the department authority to compel the production of documents and materials relevant to investigations of potential voting rights violations. And fourth, the bill places new measures to safeguard the rights of Native American and Alaskan Native voters. In 1965, Congress enacted, and in 1975, 1982, and 2006 reauthorized a statute that provided the strong medicine needed to remedy voting discrimination and to enforce our Constitution's commitment to ensuring that no citizen's right to vote would be abridged on account of race or color. Congress must act now to restore the Voting Rights Act, to prevent us from backsliding into a nation where millions of citizens, particularly citizens of color, find it difficult to register, cast their ballot, and elect candidates of their choice. The Justice Department welcomes this opportunity to work with Congress to revive this bedrock civil rights law. Thank you.
Thanks, General Clarke. Let me start the questioning. Texas is the latest legislature this year to attack the right to vote based on the lie of widespread voter fraud. Last month, Texas Governor Abbott signed SB 1 into law. It banned voting opportunities that made voting more accessible, particularly during the pandemic, such as drive-through voting and 24-hour voting options. It increased access for partisan poll watchers. It prohibited local election officials from proactively distributing applications to request mail-in ballots. The legislation also restricts the state's vote-by-mail access, including new ID requirements for absentee voters. These voting restrictions come after voters of color used all of these same options at historic levels in the last election. Now, supporters of the bill, and we've heard it this afternoon in the committee, claim you've got to do it. It's the only way to stop voter fraud. So the Texas Attorney General spent 22,000 hours looking for evidence of fraud. You'd think they really would have made their case. What they found to try to justify SB 1 was the following. Only 16 potential cases of fraud out of 17 million registered voters. And you remember what happened in Arizona. 5.7 million spent on the Ninja Turtles who were going through all these ballots. And the net result was more votes for Biden, fewer votes for Trump. So this notion of voter fraud is a ruse as far as I'm concerned. Where there is fraud and waste, we should oppose it, whatever party is trying to make an excuse for it. But in this case, there is no basis for it. I would like to ask you to put into perspective for just a moment. We know the discrimination based on voting throughout history. It's a horrible chapter, more than one chapter in our nation's history when it comes to civil rights after the Civil War. The question today is, does it take on a different context in light of the big lie, in light of the argument of the previous president that he in fact won the last election, though there's no evidence of that, and the attempt to discredit our electoral and voting process?
Thank you for the question, Chairman. The Justice Department believes that elections in our country should be open, fair, and free from fraud. We have observed that claims of fraud are exceedingly rare. Should the Justice Department encounter evidence of fraud, the department stands ready to investigate that fraud. But what the Justice Department has observed is that voting discrimination is widespread. It is a current day problem across our country, in Texas and in many other parts of the country. The Justice Department spent several years tackling the state's voter ID law. We know that the state of Texas spent about $3.5 million defending that law. The Justice Department is here to make the case for restoring the preclearance provisions so that we can ensure that elections are free, open, and fair across our country.
It seems when you read Shelby County and Bornovich that the argument being made by the Supreme Court is, sure, it was a problem in the old days, but it's just no longer a problem that would require preclearance. And yet you look back not that far in history. A three-judge panel in 2016 examining a 2013 North Carolina voting law that required strict voter ID and limited early voting. The judges wrote, quote, targeted African Americans with almost surgical precision. This was no coincidence, the court found, noting that before enacting the law, the legislature requests data on the use by race of a number of voting practices. Upon receipt of the race data, the General Assembly enacted legislation that restricted voting and registration in 5 different ways, all of which disproportionately affect African Americans. That's 8 years ago. And the question I have for you, is there evidence now of what we're seeing in the states of recurrence of this theme?
Yes, in the department's view, voting discrimination is a current day problem. The Justice Department has found that Section 2 litigation, which it brought in the states that you referenced, North Carolina and Texas, have proven to be an inadequate substitute for the important protections that had long been provided by Section 5. The advantage with Section 5 is that it blocks these discriminatory laws from ever taking root in our electoral process. While the department had Section 5 in place, the department blocked 3,000 discriminatory voting changes, about 60% of them having evidence of intentional discrimination. Our hope is that these hearings will lead to a restoration of what has been one of the most important and powerful tools for the department to do its work of safeguarding the right to vote in our country.
Thank you. Senator Grassley.
Yes, General Clarke, I'm going to quote some polls that you probably know exist, but I'm going to quote them anyway. Monmouth, 84% of non-white respondents said that they supported requiring photo ID. 62% of the Democrats said they supported requiring photo ID. That number rose to 87% among independents, 91% among Republicans. So 2 questions for you. How do you square prevailing public sentiment with your comments that voter ID is a burdensome proof of citizenship required, and your words, a bag of tricks to suppress Black votes?
Thank you, Ranking Member Grassley. The department does not believe that voter ID laws on their face are unlawful. The department carries out its work by looking at the particular photo ID law that may have been adopted in a particular state. It looks at data with the support of experts to determine who has access to the particular forms of ID that are deemed qualifying under a particular law. We follow the facts and apply the law. Photo ID laws are not on their face invalid. It really depends on where that photo ID law has been instituted. It depends on the form of the ID and the kinds of ID that may be permissible on that law, and whether or not there are disparities in who has access to the particular category of IDs called for by a law.
The overwhelming majority of Americans, as according to this polls, support ID requirements. So do you think most Americans support voter suppression because you said it would suppress Black votes?
Well, the department believes that our elections should be free from discrimination, and particular photo ID laws or purge programs or decisions to shut down polling sites may have a discriminatory impact on minority voters. And what we have found in the course of our work at the department is that these are fact-specific, fact-intensive and context-specific inquiries, Senator. These kinds of analyses are conducted by the career employees at the department who will look at a particular law, a particular photo ID law, to determine whether or not it runs afoul of the Voting Rights Act or the Constitution.
You gave me a department answer, and that's appropriate, but my question is whether you think these ID requirements because Americans say they're for them, and you say they're a way of suppressing black votes, do you think Americans support voter suppression?
Well, Senator, I think that these polls are helpful, but the department conducts its work by looking at the facts
Okay,
and applying the law.
Let me go on to another question. The Department of Justice recently filed a lawsuit against Georgia's election reforms. Will the Department of Justice bring enforcement action against New York for only allowing 10 days of in-person voting, or Delaware for never permitting early in-person voting? So if you say no to that, if you don't plan to bring an action, then how can you challenge Georgia's Senate Bill 202, which has more lenient provisions than both New York and Delaware?
Senator, I can't comment on pending investigations and if any such investigation exists, but what I can tell you is that the department is committed to protecting the right to vote in every corner of our country. In New York, for example, we recently resolved a matter involving a county that ran afoul of the National Voter Registration Act and the Help America Vote Act. We're committed to eliminating discrimination, root and branch, wherever it rears its head across our country.
I was very gratified to see that the 2020 presidential election, despite the pandemics, quote, featured the largest increase in voters between two presidential elections on the record, with 17 million more people voting than in 2016, end of quote. Additionally, in 2020, non-Hispanic blacks had a higher voting turnout than in 2016, 63% as compared to 60%. It would seem to me that we should be encouraging these high turnouts without restrictions. What about these statistics justify the imposition of pre-clearance?
Thank you, Senator. The statistics that you share certainly reflect a story of progress. But what the department has found is that in particular communities across our country, voting discrimination remains a real and ongoing problem. We saw this in Texas and North Carolina, where the department was engaged in long-standing Section 2 litigation against discriminatory measures in those places. We saw this recently in New York in the matter that I referenced involving violations of HAVA and the NVRA. We saw this in New Jersey, where we recently resolved a statewide NVRA claim. So while there has been progress, we know that voting discrimination remains alive and well in many local, state, and other jurisdictions across the country. And Section 5 has proven to be an important tool to identify and block voting discrimination.
Thank you. I have a couple questions, and as you know, some of us have been running in and out.
Mr. Chairman, do we have an order so that we will know when we're in the queue? Senator Blackburn here.
No, I know who you are. We've met before.
No,
Yeah.
I was just asking if we
Well,
had an order in the
the
queue.
Republican side would
Okay.
determine who
You
they're
got,
going
okay,
to have.
thanks.
If we go by order of arrival, of course, Senator Durbin and Senator Grassley were the three here ahead of everybody else. But so if we could start my time over again. The Assistant Attorney General Clarke, I am glad you're here. I think this is important that we all be here. As the lead sponsor of the John Lewis Voting Rights Act, I'm alarmed by the toxic and partisan rhetoric around restoring the Voting Rights Act. As a child, I remember going in the my parents when they would go to vote, and they told me this is a sacred right, everybody should have it. And for decades, since I've been here in the Senate, Republicans and Democrats came together to strengthen this landmark law. So I can't understand the partisan rancor that's going around with it now. So why is it so important for Americans of all parties, all backgrounds, to believe that this issue should unite us, not divide us?
Thank you for that question, Senator. The right to vote is one of the most central rights in American democracy. And we know that the Voting Rights Act has enjoyed tremendous bipartisan support throughout the years during its authorization in 1965, during subsequent reauthorizations in 1970, 1982, and 2006. And I am recalling the statement that President Bush made when he signed the bill into law in 2006. He observed that he was renewing a bill that helped to bring a community on the margins into the life of American democracy. The Justice Department knows that partisanship has no place when it's come to enforcement of the Voting Rights Act. This work has been about ensuring that all Americans enjoy equal access to the ballot, regardless of race, that all Americans enjoy an electoral process that is free from discrimination. The Justice Department welcomes this opportunity to work with Congress now to restore a law that truly has proven to be one of the most effective laws ever passed by Congress.
Well, for those of us, and I know you do and I do, believe that everybody should have the right to vote, Republicans, Democrats, Independents, whoever they are. We're going to preserve a democracy. Some would say this is and some have claimed, even from this committee, that there's some kind of a nefarious attempt by Democrats to usurp states' rights and sovereignty. If so, nobody in my state would allow me to vote for it. Nothing could be further from the truth. So can you explain in simple terms why the John Lewis Voting Rights Advancement Act is a balanced approach and the safeguards are included in the legislation to ensure that states have ample opportunity to assert their rights and defend their procedures?
The department has observed a number of important features about this bill. It makes bailout easier so that jurisdictions that have a clean record and a clean bill of health can exempt themselves from the preclearance obligation. We observe that there are states throughout time, such as North Carolina and Mississippi, that joined an amicus brief in the Shelby case, who indicated they enjoyed the benefits of preclearance, that they appreciated the flexibility and latitude that the process provided. The career employees at the Justice Department who handle the preclearance process have had good working relationships with local and state election officials. Jurisdictions also have the option of bypassing the Justice Department and going to the courts for judicial review instead. But there's been a long history of good collaboration between the Justice Department and local and state jurisdictions in administering the preclearance process. This is a process that has, at the end of the day, helped to block voting discrimination and has helped to rid discrimination from our electoral process.
Thank you. Well, I hope we can continue to work together on this to make sure we can find a path to enactment. I'm including in the record now the House Judiciary Committee's record addressing voting rights and the Voting Rights Act of the Senate Judiciary Committee record, and without objection, that will be included. Continue to work with us because I was thrilled to be standing with leading, if I could have that photograph back just for a moment, and I'll yield the floor. I was thrilled to be standing with leading Republicans and Democrats when we last signed this bill and saying, see, it's for America. It's not for either political party. It's for America. And that's what we want. Now to answer Senator Blackburn's question, actually, I'm told Senator Leahy will be recognizing Senator Klobuchar, Senator Leahy.
Thank you, Mr. Chairman. Ms. Clarke, let's talk for a minute about what states can do. Does California have the authority, and should it have the authority, to adopt more stringent air quality standards than the federal standards in place without receiving pre-clearance from the United States government?
Senator, this is not an area that I work in, I suppose, but this is not an area that I work in.
Yeah, what about areas that are protected by the Bill of Rights? Let's suppose that a state wants to pass laws dealing with COVID-19 that might have the impact of restricting religious freedom by, for example, restricting the number of people who may congregate in a church or otherwise. Should laws like that have to first receive pre-clearance before they can be enacted by a state?
Well, Senator, I'm here to talk about the right to vote, which falls to the 14th and 15th Amendments, and Congress has broad powers to enforce.
And I assume you'd also agree that through the 14th Amendment, Congress also has broad powers to protect other fundamental individual rights, including religious freedom. What about the Second Amendment? What about gun laws? Should a state be required to receive pre-clearance from federal officials before adopting gun restrictions?
This is not an area that I work in the Civil Rights Division, but I do know that the right to vote is unique, it's special, and it's something that the Supreme Court has routinely said that Congress has broad enforcement powers under the 14th and 15th Amendments to protect.
Sure, and those broad powers also extend to other rights that people have. Now, I think that it's important for us to remember that our nation is built on this principle of respect for the sovereign entities that our states are, and for the ability of each sovereign state, for the people, through their elected representatives, to be able to adopt laws that they deem fit. Because, of course, the sovereigns in our republic are, in fact, the people. The people have yielded some of their sovereignty up to the states. In other areas, they've yielded it to the federal sovereign. The Supreme Court of the United States has made this very clear in a number of cases over the years, including the Supreme Court ruling in the Shelby County case, in which the Supreme Court of the United States said, quote, "The federal government does not have a general right to review and veto state enactments before they go into effect." In fact, the Founding Fathers considered and expressly, decidedly rejected giving the federal government the power to provide what they refer to as a negative or a veto over any and all state laws. So we don't advocate for pre-clearance, even in areas surrounding our constitutional rights and the constitutional rights belonging to individuals. You know, if the laws passed by a state happen to violate the Constitution, we do, of course, have a procedure in place for challenging those. They go to the federal judiciary. The parties can litigate those. After, of course, the constitutional arguments are made to the legislative body considering them. If they fail there, they can raise them with the judiciary after they become law. And so we've got to be very careful that we don't neglect this principle of federalism in our lawmaking processes. And we can't do this here. We can't sacrifice this principle even for rights that we consider important, because the sovereignty of the people is also important. But there again, if the states do something unconstitutional, their enactments can be deemed unconstitutional, and the enforcement of those laws and their implementation can be enjoined. Unfortunately, we've had a number of politicians, including some progressives, who aren't satisfied with merely dictating voting procedures to the states. In fact, then Senator Kamala Harris in 2019 proposed using preclearance to usurp state control over regulations involving health, safety, and welfare situations arising in the context of abortion. Ms. Clarke, when I hear from you, your remarks and your testimony, and one of the things that I hear from you is that the average American's concern about the integrity of our elections is somehow based in racism. Fortunately, the facts don't support that premise. Now, progressives have tried to label any integrity election protection procedure, such as the laws that have been passed, for example, in Georgia of late, as somehow amounting to racist voter suppression. And yet, these provisions have strong support from voters across the political spectrum, including among minority voters. So can you tell me, Ms. Clarke, what exactly is racist about requiring a person to provide a voter ID when participating in the precious, sacred, constitutionally protected process of voting?
Thank you, Senator. So the inquiry is whether or not a particular law is discriminatory, and we won't know that until we actually look at the facts. We look at the particular law at issue, and we look at where is it being applied, and are there racial disparities in terms of who has access, to example, to the limited forms of ID that might be called for by a law. So I think the inquiry is about discriminatory effect and discriminatory purpose.
And I would note that the senator's gone considerably over his time. I didn't want to interrupt him, but I was turning to Senator Klobuchar. And I do that because we're having votes going on and people are trying to go back and forth.
Thank you, Mr.
Senator
Chairman.
Klobuchar.
Thank you, Mr. Chair. Thank you very much for being here today, Ms. Clarke. I just want to get some basic facts here. In the Supreme Court's 5-4 decision in Shelby County v. Holder, the majority wrote that when Congress establishes a process for preclearance, it must do so in a way, and this is the court decision, that makes sense in light of current conditions. It cannot rely simply on the past. How do the updates to the Voting Rights Act in the John Lewis Bill respond to the Supreme Court's critique? And do you agree that it's relevant to our evaluation of current conditions that this year alone, over 400 bills have been introduced across the country to roll back voting rights, and at least 31 of them have been signed into law?
Thank you, Senator. So the bill does a number of things. It tethers the preclearance formula to current conditions, which, as you note, is the instruction from the Supreme Court in the Shelby ruling. And I also deem these hearings that Congress has been conducting since at least 2019 to be important, because they've provided an opportunity for Congress to hear about those current conditions on the ground across the country. The bill also provides stronger protections for Native American and Alaskan Native voters, which is important, and does a number of other things, including clarifying the standards to be applied in Section 2 vote denial cases and more.
Thank you very much. Do you agree, and I know you're familiar with the Freedom to Vote Act, and we know that John Lewis Bill, let me just stop back, will stop states with a history of racial discrimination from rolling back voting rights in the future. It would also counteract some of the laws that states have already passed through a new provision in Section 2 that would apply to changes in voting laws made this year. But do you agree that in order to protect Americans' right to vote, Congress must pass both the John Lewis Bill and the Freedom to Vote Act, which, as you know, is a negotiation. Senator Manchin and myself and Senator Padilla on this committee, Senator Warnock, Senator Merkley, Senator Kaine and King, and Senator Schumer put together?
Thank you, Senator. The department is here to speak to the importance of the John Lewis Voting Rights Advancement Act today and welcomes the opportunity to work with Congress on other ways and other bills that might strengthen voting rights in our country.
All right. I was listening to Senator Lee's questions, and it made me think of my own real-world experience here going down to Georgia. I took the Rules Committee, which I chair, to Georgia for a field hearing, our first one in decades, about its new voting law, which includes egregious provisions, which is why major companies have come out against it, like reducing the number and availability of ballot drop boxes, putting new limits on early voting, allowing politicians to fire local election officials, changing the time of the runoff to 28 days and that not voting, allowing for any weekend voting during that time period, making voters put their birth date on the outside of the envelope, that's the internal envelope, instead of the day they cast the ballot, which is meant to sow confusion, not allowing for registration during the runoff period. What is the impact of laws like the one in Georgia on voter participation, especially among voters of color in both urban and rural areas?
Well, Senator, the department has pending litigation against the state of Georgia, and so I can't comment on pending litigation. But what I can say is that the case-by-case work that the department has been engaged in has not been an adequate substitute for the important work that we've been able to do when we had Section 5 in place, blocking thousands of discriminatory voting changes from ever taking root in the country.
Very good. Finally, Congressman John Lewis called voting the most powerful nonviolent tool we have to create a more perfect union. And that's how I see it. I have a state that has the highest voter turnout nearly every single election, including the last one. And honestly, Mr. Chairman, with voting laws that allow for things like same-day registration, we have elected Democratic governors, like our Governor Tim Walz, Republican governors like Tim Pawlenty, and independent governors like Jesse Ventura. I just see the difference. It's not what party gets elected. The change is that people feel like they're part of the franchise and that we're making it easier for them to vote. Why is it important, Ms. Clarke, to strengthen and restore the Voting Rights Act, particularly after several Supreme Court decisions have rolled back the Justice Department's ability to enforce the law's protection?
Senator, the right to vote is one of the most important civil rights in our country. It is the right from which other civil rights are derived, and it speaks to principles that lie at the heart of our Constitution. And we know that the Constitution vests this body with broad powers under the 14th and 15th Amendment to ensure that our elections are free from racial discrimination. And we welcome this opportunity to work with you and other members of the committee to achieve that goal.
Thank you very much.
Senator Blackburn.
Thank you, Mr. Chairman. Ms. Clarke, you're in charge of policing the Civil Rights Division at the federal level. Does it raise civil rights concerns when the government attempts to intimidate citizens who are exercising their First Amendment freedom of speech?
Thank you, Senator. We do not want intimidation in our society.
So it would concern you if there was an exercise against an individual's free speech, correct?
The First Amendment is important, and we also do not want a society with intimidation.
Did President Biden promise to keep the DOJ apolitical?
He has, and Attorney General Garland has made clear his commitment to ensuring that partisanship will not impact our enforcement work.
Okay. Yes or no? Did the teachers union write a letter to DOJ asking you to use the Patriot Act to target concerned parents who voice their opposition to the indoctrination of their children? Yes or no?
This is not a matter that the Civil Rights Division handled. I'm aware of the memorandum issued by the Attorney General, which speaks to threats and intimidation that some school officials have experienced in our country, and that's not activity protected by the First Amendment.
So you're saying a parent going to a school board and expressing their dismay with CRT or with the mask mandate is not protected speech. Is that what you're saying?
I believe the Attorney General's memorandum deals with threats and intimidation and harassment.
Let me ask you this then. Did DOJ issue the directive to the FBI to target parents in direct response to this letter from the teachers union, yes or no?
Again, this is not a matter that the division handled, but what I can tell you is that the Attorney General said that, quote, threats against public servants are not only illegal, they run counter to our nation's core values.
Do you believe it's appropriate to treat parents as domestic terrorists for daring to ask elected school board members questions about what is being taught to their children?
Senator, while this is not a matter that the Civil Rights Division handled, this is a memorandum issued by the Attorney General. I know that the department is committed to ensuring robust civil
Do
discourse.
you see any difference in somebody being a concerned parent and going to a school board meeting and asking questions, and then that individual being labeled a domestic terrorist and this being carried out by the FBI and the DOJ? Is that not a problem or a concern to you?
The Attorney General's memorandum is focused on threats, on intimidation.
So do you see parents as a
harassment.
threat? Do you
I
see
don't.
parents asking questions as a threat? Does DOJ see parents asking questions as a threat? Because we've seen reports from teachers, parents, and other members of a private Facebook group in Loudoun County, Virginia, that have been accused of compiling a list of names of district parents who oppose critical race theory in order to track, hack, and dox them, or even intimidate them into self-censorship. Should these teachers and other members of this private Facebook group be pursued by the FBI as domestic terrorists as well?
Senator, free speech is a hallmark value.
So it's free speech for teachers that want to track parents, but it's not free speech for parents that want to show up at a school board meeting and make their displeasure known and engage in public discourse, because those parents, taxpayers, are paying the bill for that. Let me ask you this. Attorney General Garland, I've seen reports of his family connection to Panorama Education over data harvesting and holding data on students and having contracts with school boards. And we've had quite a bit of discussion about Facebook and the way they market and data mine children as young as 8 years old. Are you aware of that?
This is not an issue that the Civil Rights Division works
so
on, but I'm
you all
generally
work
aware.
in stovepipes, is what you're telling me, and that you have no knowledge or information about what is being done to parents and how they are being labeled, and this directive for the FBI to go and investigate parents who are standing up for what their children are being subjected to in some public school systems. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. For the sake of everyone here, the circumstances on the floor are fluid, and there's negotiations and conversations back and forth at the leadership level. The Democrat leader is asking for a caucus immediately after the end of this first roll call, which will be soon. So I would like, in fairness, to have two last witnesses before we recess, both of whom have been here before this announcement clearly, Senator Cruz and Senator Cruz. So I recognize Senator Cruz.
Thank you, Chairman Durbin, and thank you, Attorney General Clarke. Thank you. Thank you for a lifetime of dedication to the Constitution, to voting, to finding a way where there seems to be now no way, to fighting for the foundation of our democracy, which is the right to vote. I have a picture on my iPad, and I'm smiling in this picture. I'm with Congressman John Lewis. I'm at the foot of the Edmund Pettus Bridge, and I'm holding up a piece of legislation. It's a piece of legislation that then Chairman Leahy and I and our staff had worked tirelessly on over a year. And it was to fix the hole blown in the pre-clearance section of the Voting Rights Act by the Shelby County decision, a carefully balanced, sensible approach towards restoring the effectiveness of pre-clearance in the modern era the way that it is in this bill. And in a minute, I'll just ask you to walk us through what that balance is that the now John Lewis Voting Rights Restoration Act would do. But I have to say, I'm sick at heart. I was smiling that day because I was so hopeful and because I was in the presence of a living saint, someone who had borne the blows and given his own blood in a dozen places across our country, in a dozen instances, set upon by a howling mob when he was on a Greyhound bus as part of the Freedom Rides, attacked by a Klansman when he dared to stand up and speak for his rights, challenged by folks who spit on him or beat him or attacked him or jailed him. And yet in the time I got to spend with John on 5 different pilgrimages like this, both in our country and to South Africa, he struck me as one of the most generous, kind-hearted, humorous, spirited people. The thing that always challenged me about John was that he believed in America far long before America believed in him, that he grew up in a town that was struggling, sweltering under racial oppression, and he never gave up hope. And I must confess, there are moments now listening to my colleagues and the ways in which they are ignoring or mischaracterizing or maligning or misstating the work of the Department of Justice, the intention of this bill, that I am struggling to remain hopeful. And so I'll just say this. If John could remain hopeful, if Congressman Lewis could remain hopeful, oddly confident, supremely, even serenely at times, certain that in the end democracy would win out, so must we. Even at a moment when it seems so difficult, so even hopeless. And I will challenge my Republican colleagues to be true to the decades-old tradition of this Voting Rights Act, won by so much sacrifice, being reauthorized and reauthorized, improved and improved over decades, from 1965 to its most recent reauthorization. By negotiating together and finding a way forward, we have right in front of us a tremendous vehicle. The John Lewis Voting Rights Advancement Act could be the path forward for that next step towards a more perfect union. So if you would, we've heard today at this hearing objections that somehow subjecting certain localities to pre-clearance is fundamentally unfair. It's unfair to its citizens. It's an undue burden on their state sovereignty. But my recollection was, as we first crafted it, this formula doesn't punish or shame any particular locality. It ensures voters within a jurisdiction with a demonstrated pattern of discrimination over 25 years are protected from a further erosion of their rights. And the formula permits a jurisdiction to emerge from preclearance after 10 years of a clean record. Can you just remind us briefly in the minute I've given you, Ms. Clarke, how that preclearance framework balances local government prerogatives to manage and control their electoral arrangements and decisions with protections for that most important and foundation constitutional right, the right to vote?
Thank you, Senator. If I may, I just wanted to share a recollection of Congressman John Lewis. I recall him being on the Senate floor, shaking the hands of many members of this body in 2006, leading up to that 98-0 vote in favor of reauthorization. I hope and believe that that level of bipartisan support for one of this body's most important federal civil rights laws remains possible today. The John Lewis Voting Rights Advancement Act contains a number of provisions. It contains a bailout provision that would allow jurisdictions with a clean bill of health a way to exempt themselves from the preclearance obligation. Judicial review is available to jurisdictions that want to bypass the Justice Department and instead proceed to court. There's a long history of good and strong collaboration between the Justice Department and local and state election officials. The Justice Department has carried out its review of voting laws in 60 days or less. It's done so in a transparent manner, publishing guidelines that walk the public and officials through the process that it undertakes when reviewing a voting law. And we have heard from states like Mississippi and North Carolina that told the Supreme Court in the Shelby case that DOJ is flexible and has latitude in how they handle the Section 5 process. So I think this bill, again, makes clear that there is flexibility and latitude and respect for local and state jurisdictions that are administering their local law. The goal is simply about blocking and deterring discriminatory voting changes so that they would never take root in a community.
Thank you. Thank you so much for your testimony today, and thank you for your determined and capable leadership of the Civil Rights Division.
Thank
you,
you.
Mr. Chairman.
Thanks, Senator Coons. Senator Cruz.
Thank you, Mr. Chairman. Ms. Clarke, when you testified before this committee and when Attorney General Garland testified before this committee, you both promised to be nonpartisan and impartial. I'm sorry to say that I think neither of you have lived up to that promise. Within weeks of President Biden being sworn in, the Department of Justice dismissed a Civil Rights Division lawsuit it had against Yale University for explicit racial discrimination. Yale has a policy that discriminates against Asian Americans at admissions. It does so brazenly and openly. And yet, the Department of Justice decided that preventing racial discrimination did not fit within the purview of the Biden DOJ. Now, in your defense, you were not yet there, neither was Merrick Garland. So that was merely the initial political operatives of the Biden administration doing what they believed was consistent with the preferences of the president. But just this week, after you were there, after Merrick Garland was there, the Department of Justice issued a memorandum to the FBI instructing them to mobilize against parents across the country, parents of school kids, who have the temerity to show up at school boards and express their opposition to the teaching of critical race theory, a pernicious theory that divides us on racial lines, that tells school children the lie that America is fundamentally racist, that America is irredeemably racist, that all white people are racist. It spreads racial division. Many parents are understandably quite dismayed at schools that are teaching this to their children, sometimes as young as 5. And yet the Department of Justice looked at that issue and decided to label the parents objecting to this teaching as domestic terrorists. Did you participate in discussions about the memo before it was issued?
Senator, I can't talk about internal deliberations.
You can't talk about whether
inside the
you
department.
participated in discussions about the memo?
No, but what I can tell you is that the Civil Rights Division will play a role going forward. The Attorney General has asked the department to undertake a review, and the division will participate in that review to determine how federal enforcement tools can be used to prosecute crimes.
Do you believe parents objecting to the teaching of critical race theory have civil rights in the democratic process?
I don't follow the question, Senator.
You don't understand the question whether parents objecting to critical race theory have civil rights?
The First Amendment is a core value in our democracy, and
I didn't say free speech. I said civil rights. School board meetings are democratic. They are petitioning your local government. Do they have civil rights that the voting rights gives a damn about?
Yet they have the right to express their view, to challenge the school boards, to ask.
And is it beneficial for the Attorney General to label them as domestic terrorists and direct the FBI to target them?
The Attorney General's memo deals with threats against public servants and says that threats against public servants are not only illegal, they run counter to our nation's core values.
Do you believe parents objecting at school boards are domestic terrorists?
I don't, Senator.
Do you believe Antifa are domestic terrorists?
I don't have a view about Antifa.
Do you believe the Black Lives Matter protesters who burned shops, who firebombed police cars, who murdered police officers, do you believe they're domestic terrorists?
Senator, I believe that we live in a society where people espouse different views, but what we don't want are threats.
You know, Ms. Clarke, it is
violence.
amazing that you're not willing to condemn people who are murdering police officers and firebombing cities because your politics aligns with them. But at the same time, when it comes to parents at school boards, you're perfectly comfortable with calling a mom at a PTA meeting a domestic terrorist. Ms. Clarke, with all due respect, this demonstrates why the Democrat proposal to take someone with as long a partisan record as you have and to put you in charge of striking down any voting rights law in the country that you disagree with is nothing but a partisan power grab. Let me give another example, because your division has operated in a purely partisan way. The Department of Justice dismissed the civil rights lawsuits against the state of New York, the state of Pennsylvania, the state of Michigan for those governors' policies that sent COVID-positive patients into nursing homes, forced the nursing homes to take those patients, a decision, a political decision that resulted in tens of thousands of deaths. One of those governors, Andrew Cuomo, has now resigned in disgrace, and his staff had admitted they lied, underreporting the deaths that policy caused, and yet your division dismissed the lawsuit against those Democratic governors. How are we to see that as anything other than a purely partisan decision?
The letters that were issued to officials in the matters that you referenced were put together by career officials inside the department.
Career officials can't be partisan?
This department carries out its work free from political
Are you
interference.
testifying to this committee that there are no career officials in the Department of Justice who are partisan?
Partisanship does not impact the way that we carry out our
Except
enforcement
miraculously, you dismissed the lawsuits against Democratic governors, even when their policies may have caused the deaths of tens of thousands of people. You also dismissed a lawsuit that was brought against a medical center that had a pattern of discriminating against healthcare providers that, for conscience reasons, didn't want to implement abortions, even though clear federal law protects their civil rights. Why did you dismiss that civil rights lawsuit in contravention of federal law?
General Garland has made clear, and I agree, that partisanship has no place in the enforcement
Except
work
every
of
decision you
the
make is
Justice
partisan.
Department.
Your actions contradict those statements.
Your time has expired. We're going to stand in recess and subject to the call of the chair. I want to apologize to the witnesses on both sides, but this caucus has been called at the last minute, and it relates to an issue, very timely issue, of the debt ceiling. So we will return, and I ask you to stand at ease until that opportunity presents itself. Committee stands in recess.